Hi, I'm Ken Fossen. Today we have part one of a review of the Nebraska Student Discipline Act and the matters related thereto. Our review of the Act will focus on regular education students. As you know, there are special rules for special education students, but we'll address that later when we talk about special education. So let's get started with the definitions used in the Student Discipline Act. They are found in section 79-256. Short-term suspension means the exclusion of a student from attendance in all schools within the system for a period not to exceed 5 school days. Long-term suspensions means the exclusion of students from attendance in all schools within the system for a period exceeding 5 days, but less than 20 days. Expulsion means exclusion from attendance in all schools within the system in accordance with section 79-283, which limits expulsions to the remainder of the current semester with some exceptions. And mandatory reassignment means the involuntary transfer of a student to another school in connection with any disciplinary action. There is also mention of emergency exclusions in the statutes, so let's include that here along with the definitions. The circumstances where emergency exclusions may be used are explained in section 79-264. Any student may be excluded from school in the following circumstances: A, if the student has a dangerous communicable disease, and B, if the student's conduct presents a clear threat to the physical safety of himself, herself, or others, or is so extremely disruptive as to make temporary removal necessary. At some point in your career, you'll likely run into a parent who says something like this: I am exercising my rights as a parent and directing you not to discipline my child without prior authorization from me. If you're faced with such a parent, you might want to direct him or her to section 79-257, which states, the board or Board of Education may authorize the emergency exclusion, short-term or long-term suspension, expulsion, or mandatory reassignment of any pupil from school for conduct prohibited by the board's rules and standards. If such emergency exclusion, short-term, long-term suspension, expulsion, or mandatory reassignment complies with the procedures required by the Act. In other words, the school gets its authority to discipline kids from the law, not from the parents. The only requirement placed on the school is that it follow the procedures as set out in the Student Discipline Act. So what happens if the required procedures are not followed? Section 79-261-2 provides that any action taken by the school board or by its employees or agents in a material violation of the Act shall be considered null, void, and of no effect. So we need to know what the law requires and proceed accordingly. Okay. Let's first look at the procedures required for short-term suspensions, starting with section 79-265. The principal may deny any student the right to attend school or to take part in any school function for a period of up to 5 school days on the following grounds. A, conduct constituting grounds for expulsion as set out in the Student Discipline Act, or B, any other violation of rules and standards of behavior adopted under the Act. Such short-term suspension shall be made only after the principal has made an investigation and has determined that such suspension is necessary. Before such short-term suspension takes effect, the student shall be given oral or written notice of the charges against him or her, an explanation of the evidence the authorities have, and an opportunity to present his or her version. Within 24 hours or such additional time as is reasonably necessary, following such suspension, the principal shall send a written statement to the student and his or her parent or guardian describing the student's conduct, misconduct, or violation of the rule or standard and the reason the action was taken. The principal shall make a reasonable effort to hold a conference with the parent or guardian before or at the time the student returns to school. Any student who is suspended pursuant to this section may be given an opportunity to complete any classwork. Each public school district shall develop and adopt guidelines stating the criteria school officials shall use in making the decision on classwork. The guidelines shall be provided to the student and parent or guardian at the time of suspension. So that's the end of the process for short-term suspensions. There are no provisions in the Student Discipline Act for a formal hearing, or for that matter, even an informal appeal to the superintendent. Having said that, it was interesting to read a Nebraska Supreme Court opinion where the parents of a 13-year-old student in Columbus took legal action to challenge their son's 3-day suspension for being involved in 4 different fights. They argued that the principal denied their child's due process rights even though he followed the requirements in the statute. It was not surprising that the court ruled in favor of the principal, but it was a bit surprising to see the words they used. All of the procedural due process requirements of the relevant statutes were followed. To contend, as plaintiff does, that plaintiff was denied due process rights under the facts and circumstances of this case is utterly frivolous. On that high point, we'll conclude part 1 of our review of the Student Discipline Act. Before I forget, I'd like to thank Justin Knight and Kelly Baker from the Perry Law Firm for their assistance in planning, research, and writing for this presentation. And of course, a special thanks to you for watching. See you next week.